So in this case, Gabbery versus Ireland Road Grace Brethren Inc. I'm going to quote from two things that were the impetus behind the other action. Quote a quote within. The function of summary judgment proceeding is to expedite the disposition of disputes in which there is no genuine issue of fact material to the claim involved, and a party is entitled to judgment as a matter of law. End quote. Barbray versus Indianapolis Water Company, 1980. Then it lists case number information, which also has information associated with that has metric and time spatial indicators. A party seeking summary judgment has a burden to establish that there is no genuine issue as to any material fact. Any doubt as to a fact or inference to be drawn therefrom is resolved in favor of the party opposing the motion for summary judgment. Poxon versus General Motors Acceptance Corporation, 1980. More information regarding metrics and time spatial data. A fact is material if its resolution is decisive of either the action or relevant secondary issue. Lee versus Weston, 1980. Information about time spatial location as well as other metrics. And it says, we agree with the Court of Appeals that to be considered genuine under Rule 56, a material issue must be established by, quote, sufficient evidence supporting the claimed factual dispute to require a jury or judge to resolve the parties' differing versions of the truth at trial. Astute versus Downing, 1979. Information about time spatial location and metrics. Quoting from First National Bank of Arizona versus Cities Service Company, Inc., 1968. Information about time, spatial location, and metrics. Then it goes on to say, here, the Court of Appeals held that since there was contradiction between Gabbery's deposition and his affidavit, only the trier of fact could choose which of Gabbery's statements to believe or disbelieve, and therefore the trial court had to accept the statements in the affidavit for purposes of determination of summary judgment. We disagree with the Court of Appeals' assessment of the trial court's duties and responsibilities at this juncture. The trial court certainly had the duty to take into consideration all of the statements made by the plaintiff on which he based his cause of action, since all of these statements were under oath. However, there does not seem to be such a conflict in either of his statements that any material fact is left to be determined by the trier of fact. Then it also goes on to say that they identified that in this case there was no material fact left to be resolved by the trier of fact, and the trial court properly entered summary judgment in favor of the city of South Bend. So my understanding is what this says is that the whole situation has to do with disputation of fact as fact. Now, in journalism, for instance, one understands if you are citing information in an article that if there are three credible references to something as information, then it is identified as a fact. So you don't have to provide a specific citation of the source from whence that information came. This is during the 90s to early 2000s. So you need three credible references, including presumably references that you would go to frequently that already have some established credibility with which they're associated. And if it is referred to in there in that manner, and then there are two others to support it, then it's a fact. And you don't have to have a specific citation of it as a fact. It's a general fact. And so that is one manner in which to understand fact. Who is the source and who has the credibility, right? And this is a major issue. It's a major issue because, for one thing, there were matters discussed in a case that went before the Supreme Court, General Motors versus the United States. Yet they talked about this consideration of superior knowledge. And my major understanding of it was that what happened was, in the process of the case being brought and in the case going through the appeals process, that what was of consideration was the concept of superior positioning, which also implied a sense of responsibility and demonstration of responsibility, as well as command, or rather control, when determining authority which then also had to do with identification of knowledge in terms of who actually was in ownership or possession of that knowledge, and hence would have a just cause claim to determine matters related to its acquisition but also its distribution. So, when one discusses, for instance, what was referred to in that case regarding superior knowledge, and then the understanding of making superior knowledge available or withholding information about from whence that superior knowledge came or how it was acquired, that one of the things that has to be discussed is, well, is the superior position actually legitimate as a determinant for identification of the entity that is assessing itself as being the one that's actually in the possession of it, and that this is a matter not only of command in establishing authority, but also capacity to provide and take responsibility for its welfare or maintenance. And so, when you're in a case proceeding and you're the plaintiff, you are in a different position regarding authority, but also in terms of responsibility regarding the case at hand than you are if you're the defendant or if you're the respondent. So if you make a claim and then it ends up getting adjudicated, and then you have to appeal, and then in that appeal you become the plaintiff as opposed to the defendant, or vice versa, then the burden of proof is one matter, but it's also about the production of and the composition of the knowledge base that informs the case. And so when you discuss things in a manner of identifying fact, then one of the things that entails is necessarily who do you have providing the information, including the witnesses. Now, I've just discovered this case, Sharon versus Time Inc. I'd heard about it before, but it didn't seem like something to actually that was relevant to what's going on. One of the things it discusses is how one of the motions that's available online discusses how, or one of the judgments online now discusses how Time Inc. Gave a list of people that it was going to call as expert witnesses, and there were specific kinds of manners in which they were identified as either having specialization or as having some kind of authority to be identified as having expertise in their field in order to give testimony to establishing a foundation for the considerations that were printed in the magazine as fact, right? So this is one manner, but one of the things that also has to be determined is, especially if we're talking about human beings as being the source of human capital that somebody else comes into acquisition of, then the manner in which it is identified and characterized, but then also agreed in terms of the transference or the transmission or the distribution, it becomes very important, including in consideration of its legal relevance. And so, for instance, one of the things is, consideration of the California Evidence Code, right? Under the federal rules of evidence, both the California, I said California because the specific reference I have is the Federal Rules of Evidence and California Evidence Code from 2011, right? In 2011, time spatially has a specific impact on me because 2011 is when I first became formally and officially employed by third party provider of labor services that subcontracted with the Department of Public Health in San Francisco. But that was after I had gone through a process of being identified as being mentally ill. And in the course of being identified as mentally ill, was able to be identified as disabled for certain kinds of purposes that also made me eligible for employment at that third party provider of labor services that then was able to give me the experience I needed to take the civil service exam and then qualify to be hired by the Department of Public Health in San Francisco. So those major decisions ended up happening during 2011 in California. So that's why this, as a reference point, is very specific and very concerning in regards to identification of standards that were already at work at the time that somebody else that would have been in a position to either demonstrate superior knowledge, if that was the claim they were making, or would be an authority in terms of attesting to state of mind, Or if they were somebody, for instance, that asserted that they had certain kinds of professional qualifications to make determinations about somebody's capabilities, including whether or not somebody actually had a medical disability, they would already have been, presumably, and at least as they represented themselves, in a context where they had received certification or official verification that they qualified as professionals in accordance with certain standards. And that would also include the attorney. The only time I've ever been able to speak with an attorney as my attorney, who was the one that was in charge of administering the processes connected to the claim regarding Social Security disability insurance, that determined that I was not disabled for the purposes of being eligible to receive assistance for future actions. But I was determined to have been disabled enough to be approved for compensation of lost wages from the 2 prior years, right? And in so doing, could potentially then appeal were I to decide to appeal. At that time, I decided not to appeal, and I did not appeal. But that person would have known about Rule 802 regarding hearsay. But she also should have known about Rule 803, hearsay exceptions, availability of declarant immaterial, right? And it says the following are not excluded by the hearsay rule, even though the declarant is available as a witness, right? Present sense impression, excited utterance, then existing mental, emotional, or physical condition, statements for purposes of medical diagnosis or treatment, recorded recollection. This one is important. A memorandum or record concerning a matter about which a witness once had knowledge, but now has insufficient recollection to enable the witness to testify fully and accurately, shown to have been made or adopted by the witness when the matter was fresh in the witness's memory and to reflect that knowledge correctly. If admitted, the memorandum or record may be read into evidence but may not itself be received as an exhibit unless offered by an adverse party, right? So this is one of those matters where one says, for instance, I have observed crime. I understand it to be crime. And not only do I understand it to be crime, but I understand it to be crime that's being presented to me in a manner that is attempting to extort me to agree to cooperate. I've written a report. I understand you're the appropriate reporting body and you are, or that you are involved with some form of regulatory compliance, or you're involved with law enforcement. I'm trying to turn this report into you. We can't take the report. Why can't you take the report? Now, is this because I'm not identified as somebody that's considered to be a professional? And because I haven't met certain standards as a professional, then it would not be considered an official professional work product? So, are you trying to get credit for it as being in your network of professionals who meet certain standards? And so, then if they submit it, after they allege they acquired it through some sort of surveillance or through some sort of observation, including an observation that they say was justified, including justified in consideration of a specific pretext for challenging my mental capacity, including the capacity for me to make informed decisions about my safety and matters that would impact the safety of other people. Well, does that mean you could only accept it as evidence in a proceeding that you have not disclosed and which you've not formally engaged me as an adverse party? You see, and if you do that, then you get into a whole host of other concerns and in other questions regarding your state of mind. What was your state of mind specifically when you materially misrepresented the facts of the matter in consideration of how you presented yourself as a professional? So that's one matter, right? But there's more here. Records of regularly conducted activity, like, presumably you have to sign a sign-in list. You have to sign a sign-in list whenever you're a part of a particular, training or activity. Absence of entry in records kept in accordance with the provisions of paragraph 6. Public records and reports. Records of vital statistics. There's many, many more going on here. right? But the point of the matter is that we are talking about trying to make a determination between what is actually evidence and what can be said to be not admissible as evidence. And then the determinations based on the discernment of it as evidence then goes to establishing fact and making it a statement of fact that can either be entered as an exhibit or that can be a part of what would be an affidavit or a deposition that would then be testimonial evidence that would then be used to make a determination, including one in consideration of a request for summary judgment.